Hi, I'm Professor Ashley Dobbs. I'm the director of the Intellectual Property and Transactional Law Clinic here at the University of Richmond School of Law. And today I'm here to break down a recent trademark dispute that popped up in the news between the production company owned by the Obamas and a company that provides photography, books, ebooks, and audiobooks owned by a woman named Ms. Massey in California. Ms. Massey's company is called Higher Ground Enterprises, LLC. The Obamas want to name their production company Higher Ground Productions. Now, if you've seen any of the prior videos about trademarks, you'll remember that a trademark is the unique identifier of the source of goods or services. And the first person to use a trademark in connection with particular goods or services is the one that has the rights to use it above others. And if you register that trademark with the U.S. Patent and Trademark Office, you have enhanced rights. In this case, Ms. Massey alleges that she began using her trademark with her services that included photography and film in 2014. And she registered her trademark with the Patent and Trademark Office and received a federal registration. The Obamas went to register their production company name this year, and the Patent and Trademark Office rejected their application because Ms. Massey was already there. She was using the same or similar name for same or similar goods or services. So the Obamas then did what most businesses will do in this situation, is they'll turn to negotiate a settlement deal. For example, they might try to pay the person to change their business name so that their trademark will go forward. It's not uncommon to do that. What is uncommon is Ms. Massey asked not for money, but for a part in one of the upcoming productions by the Obamas production company. And that was a hard no. So the Obamas attorney took the next step, which is taking the dispute to the Trademark Trial and Appeal Board, which is the next level up for decisions like these. And what they're seeking to do is have Ms. Massey's trademark registration canceled altogether. Can they do that? She already has the registration. Well, maybe, because one of the rules about trademarks is that you have to actually be using in commerce in a bona fide way. It's got to be interstate commerce, and you have to do so continuously. So what the Obamas attorney did is they looked around on the internet and they don't see any evidence that Ms. Massey had been using this trademark for the goods and services that she alleged. They didn't see a website for her. They didn't see any advertisements for her. So they're seeking to cancel her mark because you can't squat on trademarks, and brought this action to the TTAB, as it's called. The next step is that Ms. Massey will have to respond and provide evidence that she has in fact been using the mark continuously in a bona fide manner in interstate commerce. Unfortunately, these kinds of disputes can drag on for a long time, and it requires the parties to hire attorneys and pay them over that long period of time and engage in the discovery process. So we'll have to see whether Ms. Massey has the resources to take this dispute to the end, or whether we might be seeing her in a production from the Obamas in the future.